Hello, Left of Awesome. This week, I received a letter from Congressman Rob Bishop's office. And oh, how delightfully fallacious and nebulous and illogical and homophobic it is. So in order to properly debunk this letter from Congressman Rob Bishop, or in all probability it was really written by a staffer, but a letter which purports to be from Congressman Rob Bishop, that was in response to an email I sent to him asking that he support a congressional bill called the Respect for Marriage Act that would repeal DOMA, the Defense of Marriage Act, which was passed in 1996 and effectively banned gay marriage from being recognized on a federal level, meaning that gay couples would not receive the same federal benefits even if they were recognized in the state. So let's read what he had to say on the subject, shall we? Dear Nathan, thank you for your letter regarding the Defense of Marriage Act. It is important in our federalist system that each state be allowed to pursue its own policies without encroachment by the national or other state governments. This was the breakthrough idea established by the founders. This division of political power between federal and state government was the basic systemic protection of individual political liberty. The liberties outlined in the Constitution are political freedoms for all Americans. There is a distinction between political, economic, and social rights. When we fail to note their difference, we do damage to the philosophical institution of our law. Marriage between a man and a woman is the basic social institution in our society. Although social distinctions occur, this does not mean, however, political discrimination is justified. With this background in mind, it is understandable to see why Congress passed the Defense of Marriage Act, DOMA, in 1996. States hold the power to resolve this issue and should have the opportunity to determine their own definition of marriage, to be respected by the other states of the Union. That is why DOMA has value. Again, thank you for writing. Please feel free to contact my office in the future. Sincerely, Rob Bishop, Member of Congress. So, chances are if you're watching this channel, you could discern the innumerable flaws in his claims that were so spurious that I'm hesitant to call them an argument. But, in case you didn't, let's go over some of them. I quote it as saying that, in the end, states hold the power to resolve this issue and should have the opportunity to determine their own definition of marriage, to be respected by other states of the Union. That is why DOMA has value. And in fact, the majority of his quite short and concise and spurious letter spends its time expounding on the importance of states' rights. Now, ignoring that states' rights should not necessarily go into spheres where we're discussing individual liberties, for instance, Jim Crow laws, poll taxes, matters of segregation, interracial marriage. These were all things where states' rights was applied, and I don't think I even bothered to mention slavery. But suppose we assume a strict states' rights doctrine, so that no matter what, states should have the power to do as they see fit without federal interference, and that includes definition of marriage, even though the Supreme Court ruled in Loving v. Virginia that they didn't have the right to set their own definition of marriage regarding interracial marriage, so that clearly is not standing on particularly sound constitutional ground if we accept precedent. But ignoring all of that, suppose we accept his states' rights presuppositions. If we accept that states are to set their own definition of marriage, then what good is it to have the federal government define marriage? Why is it that the Defense of Marriage Act should state that the federal government is only to give recognition, federally, to marriages that are between a man and a woman? Wouldn't that limit the autonomy of such states as Massachusetts, which grant gay marriages? If a marriage is recognized by the state, and states should have total authority to define marriage as they see fit, and the federal government and other states should not interfere, then why is it the case that the government should have a federal law that says that that marriage is not going to be recognized on a federal level for purposes of such things as Social Security benefits, or immigration law, or various other federal benefits, pension plans, military families. Anything that a federal agency does that would involve marriage is going to be unrecognized by them, even though the state recognizes it. Wouldn't that seem to be more of an incursion on states' rights than simply, allowing the states to set their own definition of marriage with there be no federal legislation on it? Yeah, apparently not if you're Rob Bishop. Perhaps the most ironic thing about his usage of spurious states' rights arguments to justify the Defense of Marriage Act is that, in addition to the clearly reasonable Equal Protection Clause challenges to DOMA, it's denying people equal protection under the law, equal access to benefits simply on a basis of their gender and their sexual orientation, which defies the Constitution, potentially, well, that's a pretty straightforward argument that we're used to, but it turns out that the other big argument is from the 10th Amendment. The 10th Amendment, for those of you who are in need of brushing up on your Bill of Rights or who aren't American citizens or something, states that powers not delegated specifically by the Constitution to the federal government, or powers that are not reserved for them, are reserved to the states or to the people. So something that does not pertain to the common defense or the general welfare, etc., is not within the purview of congressional authority. This is effectively the constitutional basis for a states' rights doctrine, the sort of states' rights doctrine that Representative Bishop advocates, when he says it is important in our federalist system that each state be allowed to pursue its own policies without encroachment by the national or other state governments. When he says this was the breakthrough idea established by the founders, he means this was the idea that they initially implemented a bit too extremely for the taste of this country in the form of the Articles of Confederation, but maintained in the Constitution in the form of the 10th Amendment. And yet the 10th Amendment is being used frequently in legal challenges to DOMA because it directly interferes with their own power to give marriage and is an expansion of congressional authority. Interesting, huh? Then the one other big problem I see with this correspondence is his only argument that wouldn't seem to really work against him is marriage between a man and a woman is the basic social institution in our society. But that argument he never really expounds upon. He just states it as though it's fact. And then he never states why, just because it's the basic social institution, means it is deserving of special protection from the federal government. He simply states it's the basic social institution, which is effectively a naturalistic fallacy. It's an argument from, this is how things work, thus this is how they ought to work, and the government should maintain this. Rather than presenting any arguments for harm that would be done by the gay marriages being recognized by the federal government, instead he simply jumps. And it's a pretty long jump. I didn't know congressmen possessed such strong legs. Maybe he has a bunch of staffers lifting him up or something. But he effectively just jumps from, this is a basic social institution, regardless of what that really means, to, we need a federal law that protects it at the expense of other marriages that would protect the same rights this protects for homosexual couples. And finally, he closes with, please feel free to contact my office in the future. Rob, I sure will. I certainly shall. But I have just one thing to request on your part. When I contact you, sending you this YouTube video, I strongly suggest that you do not, I repeat, do not send me the same old form letter again. Either do not reply to me, or counteract my arguments. Thank you, and have a wonderful week.